Okay, I'm finally up and running. So the way this goes is that I'm going to speak until I get to the point where you should do multiple choice questions. Then you should pause the video, do the multiple choice questions, and resume the video. I might interrupt the video and post it as in two sections, just so that I don't go through the whole class before I discover that this system does not work. So we're beginning with a quick review. I hope that you have downloaded the slides for today. I have some paper versions of the slides that I can hold up. This is very, very low tech. Very low tech, it's not even working. So last time, which was weeks and weeks ago, we finished up undue influence and insane delusion. And then we started working on fraud. So undue influence, remember, is supposedly the psychological equivalent of duress. So, but it's a sort of psychological torture that forces the testator, compels the testator to do what the influencer wants. But it's actually been watered down to what amounts to bending the testator's will by taking advantage of his weakness and the fact that he trusts or depends on the influencer. So he cannot form the intent necessary to make a will because his mind isn't his own. We don't have to prove that the influencer intended to make him change the will. That would be hard to prove. But the contestant of the will can shift the burden to the proponent by showing that 4 factors are present. And these are the 4 factors. Here they are. So there's the susceptibility, which is also known as the weakened condition. That is, the testator was susceptible to undue influence. Well, you can see it on your handout. There's the influencer's opportunity to influence the testator, which is also known as a confidential relationship, because opportunity means that that the testator trusted or relied upon the influencer. There was participation in making the will, that is, the influencer was somehow involved in the making of the will, maybe as little as suggesting the terms of the will, and finally the proponent or an associate so profited unduly. So you can have a case where the influencer persuaded the testator to leave all of his estate to the influencer's daughter. All of these factors must be present. If they are, the burden shifts to the proponent to show that there was no undue influence. All right, do remember that the confidential relationship is more than just being close to the decedent. You would think that every spouse or every child is in a confidential relationship, but here the term is used as a term of art, and only a child who is a caretaker or perhaps isolates the parents from the other children would be counted as being in a confidential relationship. Okay, so insane delusion. An insane delusion is a persistent belief in facts that have no real existence and that no rational person could believe. This is not a reasonable person standard. The belief can be unreasonable without being insane if there is some evidence to support it. So if you had a reasonable person standard, then even if 25% of the population believed in some false facts or alternative facts, then all of those people having the belief would be locally insane, which doesn't sound so bad, actually. I love this slide from Erasmus, the Erasmus of Rotterdam quotation, which, again, I'm having trouble getting into the screen. He said, "A man who sees a gourd and takes it for his wife is called insane because this happens to very few people. He probably said that in Latin, and it probably sounded better in Latin. Now, for very few, you should read just about no one. No reasonable person could mistake a gourd for any woman, let alone for his wife, and therefore the fact that almost no one, that no rational person could believe this makes it an insane delusion. Okay, so now pause the tape and do the insane delusion and undue influence multiple choice questions. When you finish, if you keep clicking OK, you will get my explanations for why the right answer is the right answer. All right, so now to look at today's topic. We're going to, topics actually, we're going to do quite a few. We still have to finish up some stuff from, this is just not working. We still have to finish up some stuff from last time, namely no contest clauses and fraud and duress. And then we get to start a new chapter on construction of wills. That is, we're talking about interpretation of wills. We'll start with the plain meaning rule. The plain meaning rule, the traditional rule, said that no extrinsic evidence would be admitted to contradict the terms of the will. We'll talk about ambiguity, the fact that extrinsic evidence is admitted to clarify an ambiguity. And then we'll address the issue of mistakes. What do we do if the testator made a mistake? Can we correct for it? Most states would say no. UPC states say yes, but only if there is clear and convincing evidence of the donor's intent. All right, then. So, no contest clauses. One of the techniques that Lipper used, remember the Lipper case, that was the undue influence case where Frank Lipper drafted a will for his mother, which disinherited the children of his brother Julian. The result was that Frank and his sister took more, and so we had all of the elements in place for an undue influence challenge. Lipper's no contest clause is on page 301 in section 8, page 301 of the book, section 8. What it did was provide that if any legatee contests the will, they forfeit all benefits under the will. Well, that didn't work, obviously, because the contestants did challenge the will, and they got all the way to the Texas Appellate Court. So Lipper did something wrong. What he forgot to do was include some bait. He should have left something to Julian's children so that they actually had something to lose when they challenged the will. Now, pages 306 to 307 are the ones in the book that cover or are devoted to the no contest clause. First, there is the effect of a no contest clause. Obviously, a no contest clause is not going to magically stop all contests. What it does is force the contestant to either take his bequest under the will or challenge the will and risk losing his benefit. The challenger only loses his bequest if the challenge fails, right? So it's not true that every challenge results in a forfeiture. Only the ones that fail result in a forfeiture. If the challenger wins, well, it depends, what happens depends on what was the basis of the challenge. If he charges that the testator lacked capacity, then of course the whole will would fail if he wins, because the testator never had the capacity to make a will. If he, and what happens then if the whole will fails? The estate passes by intestacy, or we fall back on an earlier will. If the challenge is that the will was a fake, well then obviously the will that's in court is not valid, and again we go to intestacy. So a no contest clause discourages strike suits or frivolous suits, but it's still worth challenging the will if the challenger has a strong case. Now, the second question is enforcement. Will the courts enforce a no contest clause. It does go somewhat against the principles of the Wills Act, that people who have a cause for concern about the validity of the will could not be able to present that concern to the court. After all, if the will is dubious, we would want that evidence to appear before the judge. So what do we do about these no contest clauses? The UPC, I'm now looking at this slide. Well, not really looking at it because I can't get it in. The UPC gives a qualified yes to the question of does it recognize no contest clauses? Will it enforce no contest clauses? But it says that if the contestant has a reasonable case, then the UPC would allow him to challenge the will without penalty. So it says a no contest clause is valid and enforceable unless the contestant had probable cause. Of course, for this rule to provide any guidance, contestants would have to know whether they had probable cause or not. Hence, the UPC provides a safe haven. It says probable cause means that, or means evidence that would lead a reasonable person to include that the challenge was likely to succeed, and the safe haven is if the beneficiary consulted a lawyer and he was fair and honest and open to the lawyer and he followed the lawyer's advice, then he did have probable cause. You don't have to consult a lawyer, but this is one way of demonstrating that you have probable cause. Again, the no contest clause makes the contest risky, but challengers with a strong case will go ahead. So, well, if they have probable cause, they can go ahead in any case. Okay, so moving on to the next slide. So how do the states stand on this issue? So most of the states go with the UPC. That is, they will not enforce the no contest clause. They will not enforce the penalty if the challenger had probable cause. But some do enforce the clause, even if the challenger had reasonable cause. So the challenger in those jurisdictions has to be pretty confident of winning before he proceeds with his challenge. Even these jurisdictions do make an exception if the challenge is based on alleged forgery or a subsequent will, a subsequent revocation of the will. This is for obvious reasons. If the will has been forged, you don't want the forger to insert a no contest clause and thereby prevent anyone from challenging the will. So you can bring, you can bring a forgery claim and lose and not have to surrender your bequest. Or if you argue that there was a subsequent revocation, you can bring that to court, and again, you wouldn't forfeit your bequest. Okay, now do the multiple choice questions concerning the no contest clause. All right, so now duress we talked about earlier, much earlier, weeks ago. Duress means physical force or the threat of physical force or the threat of an unlawful action. The question was kind of if a wife induces her husband to write her into his will by threatening to leave him, would that be duress? No, it wouldn't, because leaving him is not illegal. So you can put pressure on people, psychological pressure, or threaten to leave them or threaten to hate them, but that's not duress. Okay, so then the final issue in the capacity area is fraud. Now, you can't remember it because we haven't got there yet, but we're going to talk about mistakes, and we'll see that the courts will probate a will that contains a mistake, or that's based on a mistake, but not if the mistake came about because of someone else's deceit. So the difference between fraud and mistake, if you have to find one, is that mistake is no one's fault, except maybe the testator's, whereas in fraud, there is a wrongdoer who benefits from his wrong, and of course the law disfavors those people, to put it lightly. So wrongfulness is an essential element of fraud. It's a very difficult test to meet, especially since it concerns the beneficiary's state of mind as well as proof of causation. So if you look at the fraud slide, you'll see that there are slightly different definitions for fraud in the execution and fraud in the inducement. I'm not so interested in the terminology, I won't ask you about it. They're pretty obviously two variants on the same thing. Fraud in the execution is usually the will switcheroo case, where the fraudulent person presents the will to the testator and it's not in fact his will, or it has some changes made to it that the testator isn't aware of, and so the testator signs something that he believes is his will but is not. Fraud in the inducement is the more common example, where the fraudster lies to the testator, and the lie is intended to make the testator change his will. So the elements, if you look at the slide, there are three or four, depending on how you count. The first is that the donor was willfully deceived. So the defrauder has to lie. The defrauder has to believe, to know that his statements are false. If the defrauder is mistaken, and he believes that what he's saying is true, this is a mistake. It doesn't have the necessary wrongfulness component, and the testator is not protected. He has to willfully deceive the testator about facts that were intended to influence the testator's bequests. This is fraud in the inducement. So he has to lie to the testator with the specific intent of getting the testator to change his will. So if he lies to the testator to save his feelings, yes, you look beautiful in that dress, or whatever, that without intending the testator to therefore change his will and leave everything to the liar, that would not satisfy the conditions of fraud. Fraud in the execution, as mentioned earlier, is a willful deceit regarding the document that the testator is signing. And finally, the testator has to make a bequest that he or she would not otherwise have made. So what does that mean? It means that if the testator would have left money to the defrauder or to the defrauder's associate anyway, then the lie didn't make a difference, and the defrauder, although he's morally just as bad as the one who did change the testator's mind, is not deprived of his bequest. Okay, so in the case on page 318, there is a case called, and I forgot the name of it, McDowell v. McDowell. That's a case where one son was good and cared for his parents, and the other was bad and did nothing for them, which kind of reminds me of a biblical story, but it happened in the modern day. The bad one encouraged the good one to take a vacation, and while he was in Florida, the bad one lied to the father. He told the father that the good one had stolen all of his money and had now abandoned him. And as a result, the father changed his will to disinherit the good son and leave almost everything to the bad son. So the elements here are, did the defrauder know he was lying? Yes, definitely. He urged the good son and his wife to go to Florida, so he knows that the good son didn't abandon the father. Did the father change his will because of the misrepresentations? Yes, the court found that. It doesn't really provide us with the evidence, but it did find that the father changed his will as a result of the misrepresentations. And now the snippet in the book, at any rate, doesn't explain where the court found evidence of the intent to influence the testator to change his will. I find that somewhat troubling. I can only think that the court reasoned that the link between the falsehood, the lie about the good brother, and the change in the will was so clear that intent was presumed. I won't let you get away with that on an exam. So in the exam, if there is no evidence of intent to make the father change his will, then the elements of fraud are not met. Okay, so there are 3 multiple choice questions on this. They tease out the importance of each of these elements. For elements, there has to be a falsehood. The defrauder has to know it's a falsehood. He has to do it in order or with the intent of getting the testator to change his will, and the testator actually has to make a change. Okay, give that a try. And now we finally get to chapter 5. We finally get out of chapter 4 and we're into chapter 5. Now chapter 5 covers a number of different topics. It's all about will construction, but that's a large umbrella. It's about interpreting or reading the will. How do we construe, obviously, the will? And today's topic is rules of construction regarding ambiguities and mistakes in the will. So we talked earlier about mistakes in the execution. Remember the line of sight test and the interested witness and purging statutes, and where the signature is, whether it's at the bottom, what is the signature. This is different. This is about reading, assuming the will is good, how we interpret the words of the will. Now I'll give you the ending, the secret right here, and tell you that if language is ambiguous, the courts do admit extrinsic evidence in order to interpret what the testator meant. So that's part of the rules of construction. If the words could be interpreted 2 ways, or then the court will accept evidence, as I said, to interpret those words, not to add anything, but to understand what the testator meant. So imagine Charlie Brown left his estate to that little red-haired girl. That's pretty ambiguous. There are lots of little red-haired girls in the world. We can accept extrinsic evidence. I understand she never appears in the cartoons, so you would have to have Lucy's testimony or something of that kind. If language is unambiguous, however, if the will is clear, but there's a mistake, then that's tough luck for the intended beneficiaries. For instance, if the testator made a mistake in drafting, if he had a typo or he used words wrongly, not being a lawyer, or if a lawyer drafted the will and made a mistake in cutting and pasting, which happens all the time these days, what with word processing and all, and if the lawyer left something out or put something in by mistake, in traditional states, those mistakes would not be corrected. So because we don't accept extrinsic evidence that contradicts the words of the will, we cannot, I mean, this is repeating myself, we can't argue, or the challenger can't argue, that those words, those clearly stated words, are in fact wrong. So if Charlie Brown left his estate to Lucy, but he meant Marcy, that's tough. Lucy, the will is unambiguous, and Lucy gets the bequest. So it is hard, really, to understand why the court won't accept extrinsic evidence, although we've seen it already in the signing cases, the Kastorf case, and various others in which there was such a near miss that nothing could be clearer than what the testator intended, but the court strikes it down, strikes the will down. So maybe I don't have to explain, or maybe I can't explain why courts are so rigid about the plain meaning rule, the rule that we don't correct unambiguous language. It's because the prime directive of trust and estate is to implement the testator's intent, and, because if we stop there, we would accept extrinsic evidence, and the will itself is supposed to be the definitive evidence of his intent. So the will provides the protection to the testator that there won't be any he said, she said at his probating. So the will is literally the last word, and the courts are not supposed to accept extrinsic evidence of what the testator wanted. Okay, so slides on the rules of reformation of mistakes. So we start with the good old plain meaning rule. And it's purple, if that helps. I'll try to find it here, the good old plain meaning rule. I'm getting the hang of this a little bit. This is the traditional rule. The will itself constitutes the only admissible evidence of the testator's intent, unless it's impossible to construe the will because of an ambiguity without accepting extrinsic evidence. So under the plain meaning rule, the testator's, the lawyer's, or the typist's mistakes will not be corrected. Things that were dropped from the will will not be supplied, and language in the will not be modified to meet unforeseen changes in circumstances. So that's a pretty harsh rule. It reads the will as it stands, even if the results are absurd. But this rule was modified by piecemeal reforms, so we're going to get to those in a moment. They include the Scrivener's error and personal usage and a couple of others. We'll get back to that after we discuss the plain meaning rule. And then finally, the same liberalizing trend that brought us substantial compliance and harmless error has been at work with respect to drafting errors. So at the cutting edge, the UPC, the restatement, and New York, of all places, say that extrinsic evidence is admissible to read the will differently from how it was written, right? So to contradict the terms of the will, but they set a very high standard. We need clear and convincing evidence of what the testator meant to say. So at that point, we're no longer construing the will, we are actually changing or reforming the will. So this is the UPC's rules on reformation of the will. Okay, so going back to the original rule. This is illustrated by the Mahoney v. Granger case on page 326. So I will turn to 326. You can see me doing it. Oh, that's not the page. It is 328. That's it. I wrote it down wrong. So the Mahoney v. Granger case, this is a great example. Helen Sullivan summoned her lawyer to make her will. This is exactly what we want her to do, right? Bring in the professionals. She left large bequests to her two first cousins. And then the lawyer asked her, whom do you want to leave the rest of your property to? So he's ending in a preposition, not good. Who are your nearest relatives, he said. And she says, I've got about 25 first cousins. Let them share it equally. Now, what happened next was a mistake. The lawyer tried to earn his fee by using real law language. He wrote, to my heirs at law, living at the time of my decease, absolutely. So she said her cousins, and he wrote my heirs at law. Now the problem is that she had an aunt living who was of nearer relation than her cousins, and therefore all of the estate went to her aunt. Now, could the cousins argue that heirs at law meant cousins? She said cousins. Could they argue that heirs at law here stood for cousins? And the answer is no. Heirs at law is not ambiguous. It's defined in the intestacy code. We will not, the judges say, we can read, the will is clear, that is the final word, we will accept no extrinsic evidence. So I'm looking at the bottom of page 329. Proof that the legatee actually designated was not the particular person intended by the one executing the will cannot be received to aid in the interpretation of the will. So we know what she wanted. The lawyer is willing to testify to it. Very embarrassing for a lawyer. Generally, that's pretty convincing if he admits that he messed up. And there was nothing, in this case, there was nothing that Mahoney could do about it. She didn't know what the term heirs at law meant, even if she'd read the will. So it's a very compelling case because Sullivan put her trust in the lawyer and he messed up big time, and the estate did not go, the remainder of the estate did not go to the intended beneficiaries. So the takeaway from that is, in a traditional jurisdiction, when the language of the will is clear, the courts will not admit extrinsic evidence. What about if the language of the will is not clear? If the language is ambiguous? Now, then, in that case, we do admit extrinsic evidence. And if you look at the next slide, which is the restatement, of course, this is so analog. Okay, this one, restatement, ambiguity defined. An ambiguity is an uncertainty in meaning that is revealed by the text or by extrinsic evidence. So, for instance, and this is only evidence that explains, the only extrinsic evidence is that which explains the language of the will. So ambiguities are things like a word or phrase that could reasonably be read in different ways, like, well, you know what an ambiguity is. If someone talks about her friends Mary and Joan and Sylvia and says, I leave her my tiara, and we don't know what the antecedent is to whom she is referring, then the text is ambiguous. She's trying to tell us something, but she wasn't clear, and we can accept extrinsic evidence as to whom she wanted to give the tiara. Or a classic one, two or more people fit the description. The testator leaves property to Desiree, and it happens that Desiree is a family name and many members of the family are called Desiree. Well, then we'll accept extrinsic evidence. Now, note how different this is from the mistake, because once we have the ambiguity, we'll accept all kinds of extrinsic evidence. People can testify, we'll look into the testator's relationship with the various Desirees. Any kind of extrinsic evidence that's relevant will be admitted. But in the case of a mistake, even clear and convincing evidence in traditional jurisdictions won't be admitted. And then the final example of an ambiguity is no one quite fits the description. So if the testator said, I leave my red car to Bob, and he has a blue car and a red truck, then we will need extrinsic evidence to discover what he exactly meant by those words. So we're trying to interpret his words. We're not adding anything or striking anything. So at the bottom of the slide, where there is an ambiguity, we accept extrinsic evidence only that explains the language of the will. So we're not going to contradict the language of the will. If the answer is that it's not a blue car or a red truck, but it's a camel, I don't know why that entered my mind, but a camel, then that evidence will not be acceptable, because that would actually change the terms of the will. Okay, so the courts argue that accepting direct evidence of what the testator meant to say would open the door to massive abuse, right? I could come in and say, Professor Reisinger left his estate to, or a portion of his estate to Seton Hall. What he really meant was to me. Well, needless to say, everybody would be going to court then. Now we'll see later when we look at the piecemeal exceptions that some courts do admit direct evidence to contradict the terms of the will in one particular case. In fact, this particular case, the Mahoney case, where the drafter, the lawyer who drafted the will, not the testator making his own will, testifies that the testator said something else and he, the drafter, made a mistake. So that's the rule in Connecticut. It's called a Scrivener's error, and that's been adopted in some places. As the book points out on page 331, you have to be very careful with things like the names of charities. So a lot of charities have very similar names. Save the Children, Help the Children, Save the Whales. And those aren't very good examples, but the book has a number of examples. Perry Manor Inc. and oh, here's a good one. The Audubon Society, Audubon New York and the Audubon Society of New York State. Those two obviously sound very similar. They're different charities, and people often, look up the proper name of their charity online and get the wrong one. Some charities even take advantage of this. They have, web addresses that are very close to a popular web address. They profit from the fact that someone left money to the Red Cross instead of the Red Cross, and that's unambiguous, and the Red Cross suddenly gets a contribution. So, in a sense, if you're trying to clarify the will, ambiguities are a good thing. Once you've discovered that the will is ambiguous, then you can bring in all the extrinsic evidence in the world. So the plain meaning rule applies only if the language is unambiguous. If the language is unambiguous, you're stuck with it. If it's ambiguous, then you can bring in all of the evidence you've got. The estate of Cole on page 332 illustrates another kind of ambiguity. The will is actually reproduced on page 333, and the final line says, "To my friend Vita Vinning, the sum of $200,000, parentheses, $25,000 in numbers." This looks a little bit like Mahoney. The lawyer testifies that he made a mistake. It was a cutting and pasting error. But there is an important difference. The court will accept extrinsic evidence here. The difference is that this case is ambiguous, that the document itself says two contradictory things. So this is what's called a patent ambiguity. I'll get back to that in a moment. The court here says that under the old rule, because the ambiguity was patent, they wouldn't accept extrinsic evidence, but here that rule has since changed. The court is going to go ahead, and given that there are these two sums written here, they open the door. The court is willing to open the door to extrinsic evidence, and what they get is evidence from the drafter himself, the attorney himself. Okay, patent and latent ambiguities. It's got a picture of a clock. Why? Because the two clocks on the same base show different times. That's ambiguous. Okay, a patent ambiguity is one like the one in Cole that's obvious on the face of the will. So anyone reading the will, even a clerk in the probate office, will see that there is a mistake here. It doesn't work. And traditionally, the minority rule, and still the minority rule, extrinsic evidence is not admitted to resolve a patent ambiguity. They just say the clause is gibberish and the will fails. And again, difficult to justify this, but I guess the problem is that at this point the lawyer can testify about the heart of the matter. Will she get 200,000 or will she get 25,000? So we're no longer interpreting the testator's words, we're picking between them, and this gives whoever is willing to testify an opportunity to change the testator's will, or the terms of the will. So on page 335, there is a statement about what kind of evidence is admitted. It's in the second full paragraph. Extrinsic evidence is to be used to determine what the testator meant by the words used, not to determine an intent that cannot be found in the words employed in the instrument. Back to ambiguities. Latent ambiguity. A latent ambiguity isn't clear on its face. It's only when the executor wants to start distributing the assets that he discovers that the language of the will does not exactly fit any one person, or does fit two people. And then the court accepts evidence as to the meaning that the testator attaches to the word. Now, at its lowest level, this is blindingly obvious, because everyone refers to, even if I left property to my sister, Erin McDowell, there may be 6 Erin McDowells in the world, and the court will not let the gift fail because there are so many Erin McDowells, well, so many, like 6 or whatever. They will determine which one I meant. So they will clarify this issue. Okay, so one way that you can distinguish ambiguity from mistake, where Mahoney concerned a mistake is something that the testator would have corrected if he'd noticed it. But an ambiguity made perfect sense to the testator. He knew what he was saying, he thought he was clear, but the executor is having trouble making sense of it. Okay, so the book gives a few examples of ambiguities. Two people or items fit the same description. So I leave my estate, or I leave my diamond ring to my sister Anne. I have 2 diamond rings. The will looks fine on its face until the executor, sorry about my machine making noise, until the executor actually wants to write the check or hand over the ring and discovers he doesn't know which ring is meant. Or the funny case mentioned in the in the book at the top of page 335, I believe, the testator left all to Danny, and it turned out that the testator had 3 lovers, all named Danny. So then we need evidence as to which Danny. Okay, so if we were in class together, I would go through some of the further examples. There's the Mrs. Wendell Richard Hess example on 336. The testator's will said, is it on 336? Wendell Richard Hess. It's an example of an ambiguity. Yes, it is. It's under C. The will said that he devised his home to Mr. and Mrs. Wendell Richard Hess, or the survivor of them, presently residing at number 17 Barbara Circle. When the will was executed in 1979, Wendell Hess was married to Glenda and lived at 17 Barbara Circle. They divorced shortly afterwards, and then Wendell married Verna. So the court says, may we accept extrinsic evidence as to what the testator meant by Mrs. Wendell Hess? In order to do that, they need an ambiguity. And where do they find the ambiguity? Rather oddly, they look at the fact that the current Mrs. Wendell Hess does not live at number 17 Barbara Circle. So there's no one who fits the description exactly. That opens the doors. We can get extrinsic evidence. And the court, look at the evidence they admitted. It's really quite astounding. They found that Glenda Lang had discussed antiques with the testator, so he was most likely to leave antiques to her. So that's not very strong evidence. Note, everyone, if you can see my apartment, I love antiques, so I hope I get lots under people's wills. So I think this is an odd case. I think this looks like to me it looks like a straightforward 2 people fit the description. There are 2 people who could reasonably be known as Mrs. Wendell Hess. A new one who was Mrs. Hess at the time of the decedent's death, and an old one who was Mrs. Hess at the time of writing the will. So I don't think you need the address, but that's what the court uses. Okay, I'm going to stop here and then restart the video. So I'm going to upload what I've got so far and then come back and continue. When I do upload it, it might be that the system simply loads everything as one document, so you might not even notice this pause.